Hi, good morning everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is a invitation only call which has been reserved for our existing clients and those of their employees who are involved in the process. Some employees we might be representing, some maybe not, because we could have a representation for corporation only cases. So I'm going to begin by talking a little bit about what I see happening in the two memoranda that have come out in the last 10 days, what their impact on H-1Bs, even green cards or L-1s, any of the employment-based cases is, and some of the things that we can do to mitigate the impact of these memoranda. I strongly suspect that somewhere along the line, the government is going to get sued on these memoranda because some of them are, I don't know if they are violative of the law. I haven't really spent enough time looking at the entire background, such as due process, some of the constitutional principles, but certainly appears to be extremely unfair the way they are implementing the immigration rules. And definitely underlying all of this flurry of memoranda is a desire by the administration to curb immigration of all sorts, even though they began by telling us that, oh, we are going to go only after criminal violators, which then expanded to everyone, which has now expanded not only to people who don't have documents, but also to people who are legally in the United States or want to be in the United States legally. So they have pretty much covered the entire field and spectrum of immigration with these memoranda specifically. Let me begin. I sent out this morning, before we got started, I sent out a set of presentation, I want to call them documents more than anything else, just so that you can follow along. If you have a link to that, great. If you don't, it's not really that important. I want to begin by talking about the first memorandum. Let's go back. What happened? Yes. The first memorandum, which was issuance of notice to appear when a case is denied. This memorandum is extremely unfair, and I think this is a very weak memorandum. It might become a problem for the government. As I said, I haven't really looked at it in detail, but there are elements in it which are very problematic and could become a due process issue. So let's begin by understanding what the government is saying. Let us say I have filed for an H-1B extension. My current status is expiring tomorrow, but I've filed my application. Application has been received by the government in a timely manner. What this memo says is, if 4 months later we deny your extension request for any reason, it doesn't say any specific reason, for any reason, whether it's a mistake by the USCIS officer, as soon as we deny the application, we will start deportation proceedings against you. Why? Because your prior status has now expired. So once again, if your prior status has expired, by the time they make a decision on your application, whether it is an H-1B extension, H-1B transfer, change of status from F-1 to H-1, or an L-1A application, L-1B application, if by the time your application is decided, and you as in the beneficiary, and of course very important for the employer as well, if your status has expired, we will put you in deportation proceedings. And the problem is, if once you are put in deportation proceedings, you cannot leave and you cannot work. So it puts you in a very bad situation. And the way the immigration court backlog exists right now, 700,000 pending cases, it could be months, if not years, before you go in for the first hearing with the immigration judge. So that puts you in a really, really bad situation. Government says once we issue the NTA, which is the notice to appear, that's the first step in the deportation process. By the way, deportation these days is called removal. The concept is the same, although the words differ. So if they put you in removal/deportation, you cannot leave. If you leave, you are barred from coming back to USA for 5 years. There is a clause, I think, for additional 5 under certain circumstances, but 5 years is a given that you're going to incur. So what is an NTA? An NTA is a notice to appear. USCIS can serve that. They could even earlier, but they used to defer that to the ICE, which is the Immigration and Custom Enforcement, to take care of these matters. But now the Trump memorandum says you've got to do it. As soon as you deny the application, you've got to issue an NTA. Now the question is, how quickly will they do that? Will there be a little bit of a grace period, 3, 4, 5 days for me to leave? We just don't know. Once the NTA has been issued, what if it has not been served? You have not received it yet. That's a gray area. I've talked to a couple of experienced deportation counsel just to get a sense of what they feel about this is. Our work was pretty much focused on federal court. So once you get out of immigration court, that's when we take on the case. But it appears that we are going to go back into immigration courts now to fight these things out. So when the benefits application is denied, H-1B, L-1, even tourist visa, whatever is denied, you can expect to see a notice to appear and you cannot leave. Now, if I were the counsel on the case, I would probably want to negotiate with the government to see if I can get them to take back the NTA so you can depart without incurring any consequences, or to even file a motion with the immigration court to allow voluntary departure, which is typically in these circumstances given for up to 120 days, and you get to depart, and there's no issue here. Another problem with staying in USA past your denial is that if you stay past 180 days, you are now subject to 3-year bar unless you are leaving under certain circumstances based upon the immigration court's discretion. So it gets very complicated. Government, with one stroke of a pen, has made our situation a lot more complicated than it needed to be. So we've got the unlawful presence issue to deal with. We've got the consequences of departing. But voluntary departure, of course, or setting aside of the NTA are options that are still available. Many people have logged in since I started speaking. I just want everybody to remember that this call is being recorded. It will be made available publicly. So when you ask a question, feel free to conceal your identity. There's no need for you to tell us who you are. This call was basically invitation only. And at any time you have a question or a comment about what I'm saying, feel free to press *5 on your telephone. *5. So if you have any questions so far, press *5. Okay, it looks like I am clear so far. So one thing I want to make clear is that this memorandum doesn't say, oh, okay, there is one question. Go ahead, sir.
Good morning, Rajiv. I had a question about, can you address any of the steps that employers need to take, especially small employers, need to take to sort of be on point with the situation so that, we are prepared versus, finding this afterwards?
I think the problem here is not so much that you could do something to prepare. There are lots of things we can do to prepare, and I'm going to come to that in the second part of this discussion, which is the second memo they've issued, which basically says, we don't have to issue you an RFE. If your case is not approvable, we'll deny it. Okay, so that's the second part of the discussion. When you combine these two memoranda together, they are trying to discourage people from H-1Bs, L-1s, any kind of employment-based visas. In fact, any kind of visas at all, or any kind of legal statuses at all. So I'll get to that. I don't think the problem is what you can do to prepare. The problem is, what do you do if there is unfair denial, and there are a lot of those around? If you look at the Administrative Appeals Office appeal decisions, there have been more decisions in the last 3 months than in the last 2 years together, I think. I haven't done the numbers, but that was my impression. And it appears that California Service Center has the doubtful distinction of being the first in line of denying people's cases. So it isn't that you can't prepare for it. You can make the best case you can, and we're going to have to change the way we work. It's going to all change completely. The new memo is effective from September 11 onwards. But this memorandum about the NTAs is effective right now. So there isn't much you can do to prepare other than the preparation of the best possible case. I just have no defense against unreasonable government action, except where Congress steps in and changes some of these extremely draconian policies that make no sense in the context of modern business. So to answer your question, what can you do to prepare? Not really much. Sit tight. Do you have any other question I can answer?
I'm good. Thank you, sir.
Of course. Okay. So getting back to what is going to happen is, so if my case gets denied, I can still file an appeal. That's not forbidden. I can still file a motion to reopen or reconsider, but none of this is going to stop the deportation proceedings that are going on against me. Government in this memo says, if your administrative appeal or MTR is successful, USCIS will inform ICE, who will then discontinue the deportation proceedings, removal proceedings. But it really is such a huge chance to take, but I don't see what else we can do. So like I said, with a stroke of a pen, the process has been made a lot more complicated than it really has to be. But that is the way this government wants to handle legal immigration. I suspect that with this memorandum and the next memorandum combination, you're going to see a lot more appeals. You're going to see a lot more court actions, and our entire firm is now gearing towards much higher volume of litigation. We didn't have to litigate basic cases, but it looks like we might end up doing that because many of these processes are so time-consuming that going to court is a better option, if possible, not always possible, if possible, to ask the court for something called a writ of mandamus, which means make the government do certain things. Let me just move some part of this. Okay, so I just moved the slide a little bit. Some of you have in the links to the slides that I'm looking at. They're just an outline of what I'm discussing. So I think we're going to end up going to courts a lot more, asking for mandamus, asking for what is called equitable tolling, which means while my case is being decided, there should be no unlawful presence issue. And of course, ultimately asking for a relief. The problem is, remember, because of the constitutional theory of separation of powers, the executive has the function of discharging or executing the laws. Congress makes the laws, and courts interpret the law and interpret the laws and their execution and make sure government acts constitutionally. So when government acts, their actions can be reviewed in a very limited manner. The court cannot substitute its judgment for the judgment of an executive who's supposed to be charged with executing the laws. So there are some limitations there. Nevertheless, cases are filed and cases are won. So we might be heading into that era. Not the best thing in the world for us or anyone, but that may be the way to go. And like I said in the beginning, some of you had not yet logged in. Before we started the recording, I had made a comment that from several of the agencies, immigration lawyers, association, councils, there are agencies and councils that specialize in going against the government in litigation for draconian laws, either as class action or individual actions. I haven't heard anything, seen anything publicly from these agencies. Makes me wonder what's going on. Part of it must be like I did. I went back and reviewed the entire context of the law. I looked at the regulations, the history of the regulations, to see where we could argue against the government for these policies as and when they get implemented against any of our cases. I don't know if government is going to get sued and if we are going to be able to win cases on policy. But individual cases, of course, have to be assessed individually. I'm going to go on to the next part of the discussion, which is denial without RFE. So another memorandum that came out a couple of days ago, government said this. They said, look, there are three kinds of angles to look at a petition or an application. One angle is, have you submitted the entire required evidence? What is required evidence? Our forms and form instructions tell you what the required evidence is. So for instance, when you file an H-1B asking for a change of status, you must submit your I-94, copy of your I-94. That's required evidence. If you don't have that, we will deny the case without a notice of intent to deny and without a request for evidence. We'll just deny the case. So required evidence, if it is not a part of your filing, we will deny your case. Okay, that part I can understand. The part that has become bothersome, of course, there's another angle there. They talk about statutory ineligibility. So if you file for something which you don't qualify for example, you exhausted 6 years of H-1B and you have no reason to get an extension beyond 6 years, that is a statutory ineligibility, will throw your case out. Same for L1B, 5 years completed, or L1A, 7 years completed. So it all depends on statutory eligibility. We will deny the case without an RFE and without a notice of intent to deny. If somebody doesn't understand the difference between these two, please feel free to ask me. You can *5. If you press *5 on your phone, I'll be able to unmute you and answer any questions you might have. Feel free to do that while we are discussing this matter. The part that bothered me about the new memo that talks about denial without a request for evidence was that traditionally, when the government first wrote these regulations back in 2007, they said, and I have looked at the history of these regulations, they said that, look, we have the right to deny your application if you're not able to establish eligibility. So we are talking about something beyond statutory denials, denial for required evidence. Now we are talking about denial for recommended evidence. So for instance, I'll take an example. I recognize the companies who are here, including the company who had asked for this call. You folks are very heavily focused on H-1Bs. Of course, some of you on L1s as well. I see a couple of multinationals. When you file the application, typically you don't submit every lick of evidence that is needed. In fact, sometimes it is not even a good idea because there is so much you can submit. Where do you stop when you start submitting evidence? For example, in an H-1B, what do I cover? Do I cover specialty occupation issue? Do I cover employer-employee relationship issue? Do I cover control issue, which is a part of employer-employee relationship? Do I cover duration of the project issue? There are so many issues. So that means when we now file, beginning September 11, when we file an application, we'll have to file an application which is complete in every respect, even though we don't know what every respect is. And that's what bothers me. There is just too much discretion left in the hands of the USCIS officer. And also, many of these officers are very poorly trained. The laws are complex. There are so many interrelationships and interconnections. For them, it's an easy mistake to make to deny a case, but that denial can then put you, going back to our old discussion, into deportation. And there's something very wrong with the way they are handling this. Can they do it under the regulations? It looks like there is an argument from the government that they can. We'll have to see what the courts end up saying on these cases. When they deny cases based upon recommended evidence or failure to submit recommended evidence, things become a lot more complicated. So we are going to have to rethink as a firm how we are going to present these cases, how we are going to charge for them, because everything has changed. All of a sudden, we're not just filing an application with the evidence that is required. We are filing with the evidence that is desired. That means the size of the filing went from maybe 30 pages to 150 pages. So all of a sudden, you're looking at a lot of information and a lot more work. And if you are doing your own filings or some of your own filings, you need to be aware of that. The memo had some areas where it wasn't quite clear. It looked like they were saying two different things which were diametrically opposed. And let me see, I think I have a copy of both memos here. This is the memo that talks about NTAs. So this is the memorandum effective September 11, 2018. And they talked about, they said, this is on page 2 of the memorandum. This policy is intended to discourage frivolous or substantially incomplete filings used as placeholders. It is not intended to penalize filers for innocent mistakes or misunderstandings of evidentiary requirements. They want us to be diligent in collecting and submitting required evidence. Now, this is odd. The phrase required evidence has a meaning. It is not the same thing as recommended evidence. So there's a lot of confusion in this memorandum. Nevertheless, this memorandum is now a part of our framework, and we have to prepare for it. To sum what we just decided, you have a problem when a benefits application is denied because an NTA can be issued and will be issued. An NTA starts deportation. You can't leave. You can go to court. You can, where appropriate, you can file appeals. Appeals take a long time to decide. So you are running into the risk of unlawful presence, 3-year bar, 10-year bar, when you are fighting this situation. That's one part of the problem. Second part of the problem is when they deny cases without an RFE, we have to file cases that are comprehensive to the extent of being ridiculous. Because many of the times, the recommended evidence is not really required or even considered by the government. There is enough of a demonstration for the case to be decided in our favor. I'll give you an example. What if I have a degree in electrical engineering, but I'm doing a job as a software developer? How far do I go in demonstrating that I'm qualified? Do I have to really get into an experience evaluation? Do I have to get into expert evidence, and it looks like that's what we might end up doing. It's still early. We have till September to see if there is any reshaping of this policy. But as of now, we are going to prepare for the worst and prepare each application as though everything must be demonstrated at the outset. Anybody has any question? *5 so far. Okay. Let's go on to then what should we be doing? Avoidance strategies. First thing is, if you are doing cases like extensions or amendments or transfers, file as early as you can. So if you can apply 6 months ahead, apply 6 months ahead, because that gives you enough time, especially if you do premium processing, so that even if the case is denied, you have enough time to file another application, using that denial as guidance for what else you should submit. It has become extremely complicated now to prepare cases and to anticipate what will and what will not lead to a denial. There are just too many things. As much as the gentleman who had asked me a question, how do we prepare for this? And the answer is, really there's not much you can do. What if the USCIS officer is ill-trained? What if the USCIS officer drops a key piece of evidence? It's not unheard of that USCIS ignores or drops a key piece of evidence and denies the case. We are left dealing with the consequences of ill-trained or careless USCIS employees, both of which are a part of the equation here. So apply as early as possible, file premium. One of the options, if there is an RFE and we are responding to an RFE and it looks like this is going to be a difficult case to win, your lawyers, which is us, and we need to have a discussion whether we should have you leave USA and wait outside USA while we deal with the RFE, so that when they deny, if the NTA is issued, we can take it back to the government showing that you already departed. If you depart before the NTA is issued, there's no penalty. The problem is now you have to go get a visa stamping if you don't already have a visa, and the visa stamping itself can be a long process. So even at the consulate level, government is trying to delay us and deny as many cases as they can. One of the key things that we've been suggesting to people for years, and this may not be relevant to H-1B, for green card cases, when you have applied for adjustment of status, keep your H-1B or L-1, whatever status you have, also simultaneously alive, or E-1 or O-1, whatever status you are on, so that if something goes wrong with the E-visa, AOS protects you, or the L-1 visa, AOS protects you. If something goes wrong with the AOS, which is the I-485 form, then your H-1B or L-1 or E or O protects you. So that would be another thing we would recommend, and we definitely have to be open to filing more lawsuits, much more so than we used to. That, ladies and gentlemen, is where we stand today. Does anybody have any questions, any concerns? Because I'm pretty much at the end of my presentation. Also, from our own team, I know we've not had a detailed discussion. I was hoping to roll it all into one. Feel free to ask any questions, folks. Anything that you think I need to address, please feel free to bring it up. Press *5 on your telephone. *5. Once again, press *5 on your phone if you have any question. Okay, it looks like we are done here. Oh, there is one. Okay, very good. Yeah, go ahead, please. I can hear you. Go ahead. Area code 501. Go ahead, please. I don't know what happened. Well, you always have the option of calling me back or emailing me at help@immigration.com. That's my email. help@immigration.com. Anybody from our team? Anybody from... Yeah, I can hear you, sir.
Hello, sir. Able to hear?
Yes, I can hear you.
So if we file now, that is before September 11th, will new provisions be not applicable?
Well, let's look at what is new. New on September 11 onwards, any filings we make have to be quote unquote complete, and we have to guess what the government considers to be complete. So any applications you file by before 9/11 are not covered by that law or by that policy. So the answer to your question, yes. That particular memorandum is not applicable, but the memorandum about notice to appear NTA deportation is applicable.
Okay, thank you.
Oh, you're welcome. So, folks, thank you all for being here. And if you have any follow-up questions, reach out to your case managers or to me, help@immigration.com. We have recorded this call. We'll make it publicly available for all of you, as well as for other members of the public or community who need access to this information. Thank you all. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.